a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your lordship to determine that in other ones. But the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay of proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was... Please, so we urge your lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter application with respect, is an abuse. In any event, none of them merits. We urge your lordship to dismiss it.
Please, let's save the time of the court.
We appeal your lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my lord.
Thank you, sir. Defendant, you have one or two words to say?
Most certainly, my lord, and I'm most grateful. My point is a very simple one, my lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Opara is okay. Where are the others? Hey, Joffo, the other. Yes, you just have 2 minutes for this. Yes. Yes, up 2 minutes for this.
Thank you, my Lord. I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my Lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my Lord, once a matter borders on jurisdiction, stay can be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my Lord, to the appeal court for the determination of these very key issues. And also, I reiterate that AJA is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my Lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my Lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my Lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Just summarize?
Yes, please. I ask, my Lord, that I be granted bail on very favorable terms, given that a concurrent judgment of the Supreme Court of Nigeria determined, my Lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my Lord.
Thank you.
That's it.
You may sit down. I'm going to read extempore as the application and all before these courts. The defendant filed 3 applications after the matter was adjourned to today for judgments. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicants in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the referred questions by this court to Court of Appeal. The third motion has to do with the notification to file written address. As defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the processes filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law, and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in these courts. And these courts have made an order that all preliminary objections or issues shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings the statutory law governing criminal procedure in Nigeria, to wit, Administration of Criminal Justice Act 2015, by Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, these courts shall not entertain same. as regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of these courts, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to sin. The court will determine all this issue in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not permit.
The defendant?
My Lord.
Consultant, can you tell your...
My Lord, I will not, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another idea that FAN was here, my Lord, another idea that FAN said, at the right time we contradict and provide a piece of evidence. A piece of evidence didn't become that. I need to write my family address, my Lord,
on the count charge which reads thus.
My Lord, my Lord, I'm saying it clearly.
Defendant.
I'm trying to come to address.
Defendant.
What is the family address? The Constitution. My family address.
Defendant.
The family address.
Can you listen to the court?
My Lord, please.
Can you listen to the court?
Please, my Lord. I need to find my family address. This is the Constitution.
I appeal to you to comport yourself this temple of justice.
My Lord, you are blessed. You are blessed. This is not law. You are blessed. It's not law.
Please, I beg you to comport yourself.
My Lord, this is not law. Show me where it says you can waive my right to address.
Beg you to
Show me.
comport yourself.
Show me where it says you can waive my right to family address. And I think that
You
show me.
in the
My
name.
Lord, you are conducting the case for them. You are wearing the case for them. Let them show me the Constitution. Show me where it says you can waive my right to family address.
You have the right to appeal after my...
No, my Lord, this is a perversion of the court of justice. This is not law.
Can you
It is not law.
excuse me?
My Lord, I cannot excuse.
Let him take
It's not possible. It is not possible, my Lord.
Take him.
You must show me where the Constitution
Is that how you brought the cameras? Is that how you brought them today?
Please.
You didn't bring the speaker before you brought it today?
Please.
Show me where it says you can tell me on your repeat law. Show me.
Please get the microphone from him, please.
I said, show me. Show me.
Excuse me.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
I'm under trial. And I must address the court. Wait. No, listen to me. Please. The judge must listen to me. No. Wait. Wait. I'm asking a very simple question. No. Wait. Please. This is Supreme Court. Wait, hold on. This Supreme Court here. Hold on a second. May please your lordship. I said, hold on. May you please your lordship. Please. May I refer your lordship to section 266 of AGJA? It's not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. When you have the right to waive my right to come and address. Show me. It's what the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please take him out? I will come back.
You can't show me.
I rise.
Wait, hold on.
I'll come back in 5 minutes.
Show me where it says you can waive my right. Show me the place I'm asking you. Show me. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. A judge. You can't be a judge. You don't know law. You don't know law. Nonsense. Where is the family to address? Where is it? Which law gave you the right to waive my family to address? Which law gave you the right? You will take a try this to the place I try with me. What's this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. I'm going down talk. Don't talk me. I'm warning you, don't talk me. I'm warning you, don't talk me. Don't talk me. Don't talk me. I said, don't talk me. Don't. Smart people. You don't know law. Show me where it says you can wear my right foreign address. Show me the law. Show me the law. Omotosho, show me the law. You don't know law. They are demoting you. You're writing rubbish. Show me the law. Unaddressed affidavit. You say you waive it. Are you doing their job for them? God will punish you now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask Omotosho, where is the law?
Let's go, please.
Where is the law?
Let's go.
Lawyers, judges, don't even know if we are at each other. I'm so disappointed that I don't engage in this. It's good we say it. From the Chief Justice, from the Attorney General, from the DSS, from lawyers, judges, they are all Yoruba. Finish what I want. No, let me stop.